Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Hello! Another day of working on your practice skills or your study skills and review for the NALA exam. This is for the debtor, creditor, and bankruptcy law section. And we head now into the Chapter 12 Bankruptcy, which is a bankruptcy chapter available to family farmers and family fishermen with regular income. So keep in mind that what we mean is regular income is that basically they're still in business. So for Chapter 12 Bankruptcy lecture and for the Chapter 11 Bankruptcy lectures coming up, and just keep in mind that we're dealing with a debtor who's doing a business, and the business is the sort of the safety. It's the net of this bankruptcy. The income from the business is important, obviously. And it's as opposed to most of the other Chapter 7 individual bankruptcy filings and even Chapter 13, where there a lot of times, almost all the time, and we look at the statistics on that, I think individuals were filing bankruptcy. Chapter 7, let me see what this says. I can get it up close enough to my eyeballs to see it. Under Chapter 7, business filings were 12,582 out of, 310,000 in all filings. And then Chapter 13 goes to business filings being only 1,520 of 2,907 plus filings. My point that I'm making is, keep your head in the context as you listen to the lectures about these entities, and try to imagine a business. It's a business being operated, and so some of the things you'll see required in the plan, required in as you're going through, the types of motions that come up, the types of complaints that inure. It's all based on business. So kind of take yourself out of a paralegal class for a minute here and put yourself in a business class, and kind of try to think of it from that lens. I think that'll be useful. So, moving on. Sorry for the long introduction, but I did feel like that would be a help to you. I would also check out all of the lectures. Look at the what we're going to look at next, the next slide. Could recommend that look at all of the lectures, list these lecture objectives, and maybe build a chart that kind of compiles main ideas that you'll see clearly in the lecture objectives. Maybe build out a chart that the top row of the chart might be Chapter 7, Chapter 11, Chapter 12, Chapter 13 across the top, and then on the side, the left-hand column, maybe pick up some of these major topics, and then in each cell
next to that column title, that row title, so you build a column. Those have the main ideas, a single word if you can, and do a comparison chart. I'll tell you what happens when you do that and you have it right in front of your eyes. You see similarities, and when you see those similarities, you can almost just forget the little details. They're all the same. If the petition filing is the same, it's the same. If the clerk's notice is the same, it's the same. If there are little nuances that are different to it, put that in the cell and maybe highlight it in red or color that you like, that just points out this is what you need to remember. It's the same. Nothing changes except these little nuances. And then memorize those, because you will have a great memory. I find that visuals really help me. So I will stop again and get going on this lecture. Procrastination, not really, but anyway, these are our objectives. I looked up the statistics for the 12-month period ending December 31st, 2024 to learn how many Chapter 12 bankruptcy filings there were in 2024. And as you can see, there are not that many. However, the figures began to rise in the first quarter of 2025 alone, because of the rising financial stress in the agricultural sector that has emerged. So, for that reason, you're studying for this part of the exam, because in 2024, 259 people were served in a Chapter 12 bankruptcy, or 259 farmers or family farmers and fishermen. That's a small group, but it's rising, and having, and again, those comparisons like you can put together on the chart can also help you say, it's all the same, they're just different requirements in these places, these little tucked in places. Almost would do that for you, because it does interest me to do that. Anyway, I'm not gonna. Moving on. So how do we define? We like definitions to begin with. How do we define an individual or individual and spouse under family farmer? So the definition of family farmer. Well, every 3 years there's a dollar amount adjusted, but you need to calculate by adding the aggregate debts and ensuring they don't exceed $10 million. And at least 50% of the aggregate non-contingent liquidated debts arise out of the business of the farming operation, and more than 50% of the debtor's gross income for each of the second and third preceding tax years must have been received from the farming operation. So again, this is a business lens. To be eligible as a family farmer debtor under Chapter 12, these 3 things have to happen. And just looking at that from the angle that I gave earlier on business angle, they've got debts. They're not the type that are contingent on anything. Well, they will have that, but at least 50% of that, it can't be more than 50% are contingent liabilities and that sort of thing. And these are coming out of the farming operation, not from my household operations. And then the gross income, obviously, it has to be a legitimate business. It's actually earning money. So think of that, these criteria under that standard. A partnership or corporation can be a family farmer debtor, and they have the same requirement. They have some requirements also. First of all, the ownership has to be looked at. If it's partnership or a corporation, more than 50% of the outstanding stock must be held by one family conducting the farming operation. So it's a family farmer. It's a partnership or corporation designed for farming. And there's that family nomenclature of 50% or more. more than 80% of the value of the partnership or corporate assets have to consist of assets relating to that operation. That's 80%. And the aggregate debts must not exceed 10 million. And we then return back to what we just saw for the family, farmer, individual, or spouse. Not less than 50% of the aggregate non-contingent liquidated debt must arise out of the farming operation. And if they issue stock, the stock must not be publicly traded. So that would be the definition of a family farmer. That is a partnership or a corporation. And then on the previous page, it was if the debtor is an individual or individual and spouse. Then what is a family fisherman? The aggregate debt must not exceed $2,268,550. I did mention this on the previous two slides, but these dollar amount adjustments are made every 3 years. And at least 80% of the aggregate non-contingent liquidated debts must arise out of the debtor's commercial fishing operation. And more than 50% of the debtor's gross income for the preceding taxable year must arise out of the debtor's commercial fishing operation. So that's an individual or individual and spouse qualifying criteria for falling into the definition of family fisherman, thus being eligible to use this chapter of the Bankruptcy Code. If the debtor is a partnership or corporation, you'll see the same standards here as well. So the amount here has changed. The aggregate debt is what's changed. The other information is the same, and in the operation of the business is obviously a family fisherman versus family farmer. And this one, does, as you see, does not have that family component of unissued stock. Or issued stock. Oh yeah, no, it does. I'm sorry, excuse me. Must be held by a family. So anyway, same kind of criteria as the family and farmer. Advantages of Chapter 12 versus a Chapter 7 bankruptcy. Chapter 12, they keep their non-exempt assets. So in Chapter 7, remember, non-exempt assets are in one way, shape, or form liquidated into cash to pay creditors. In Chapter 12, their disposable income to pay creditors, they use their disposable income to pay creditors as much as they can over the term of the plan. And they can cure defaults, which is to, this was discussed in Chapter 13, Lecture 2, but I probably didn't do a good job of explaining it. When they cure defaults, or I worded it a little bit differently. When they cure defaults, like I'm already behind on my mortgage, on my I'm trying to think of a good example for a farmer or a fisherman. To me, they're not my forte. I just don't know. But let's say I have a barn, okay, and I got a loan on it, a mortgage on it, and it's fallen behind. So it's secured. It's subject to a lien, a mortgage lien, and so the cure, but it's gotten behind by, for a year I haven't been able to make a payment on that mortgage. Debtors can bring that current. So curing default, that's what that means. And the automatic stay extends to co-debtors on consumer loans. That reminds me of Chapter 13. And debtors can pay non-dischargeable debt without post-petition accrual of interest and penalties. So yeah, if it's debt that they're going to have anyway, it can save interest and penalties because they don't plan on liquidating in any way the debt. And it's non-dischargeable, so the decision can be made to go right ahead and pay it to avoid those problems. More advantages, Chapter 12 debtors can receive a discharge more frequently than 8 years, so they have more. Chapter 7 cannot be refiled except after expiration of 8 years. And Chapter 12, they can return more frequently than you can in a Chapter 7. And there's less stigma, like we covered in the Chapter 13 bankruptcy lecture.
Okay, so disadvantages of Chapter 12 versus Chapter 7. Debtors are in bankruptcy for 3 to 5 years, as opposed to a Chapter 7, which is over in a few months. And they need to live on a tight budget in Chapter 12. Chapter 12, trustee is paid a fee under the plan, and that reduces the amount to pay creditors. And attorneys in a Chapter 12 charge higher fees because of the additional work involved. And creditors may be less willing to extend credit to debtor during the term of the plan. So how is one initiated? Well, it follows the same path as a Chapter 13. So again, look for these similarities and then find the differences. If the debtor is an individual, the debtor needs to be briefed by an approved nonprofit budget, as in Chapter 7:13. And the petition, as patterned after Chapter 13, it's closer informed to the Chapter 13 than to other operative chapters of the Bankruptcy Code. And filing of the Chapter 12 petition looks a lot like the Chapter 13 petition filing. And documents mostly the same, the procedural forms, schedules, statements, etc., as well as when. So that, again, nice to know these similarities, so you can just wipe those out of your brain. Learn it once, put it out of your mind. And the Chapter 12 plan does differ from the Chapter 13 plan. Or does, yes, it does. The significance of filing a petition. So once a petition is filed, the same thing as happens in a Chapter 13. It constitutes an order for relief and triggers the automatic stay, and obviously creates this bankruptcy estate. The co-debtor stay goes into effect, again, only on consumer debts, and the estate includes the property of the debtor's property at the time of filing and the debtor's earnings and property acquired during the term of the plan. So, again, imagine that little business running. You can't just do this and let everything live on the plan that happened before. There's a continued interest in all business happenings on the part of the bankruptcy, and things are part of the estate in this light, because business is obviously less static than personal life. More areas of significance include they retain possession of property during the plan, and so the debtor is a debtor in possession and remains a debtor in possession unless they're removed for some cause, and fraud, mismanagement, or if the confirmed plan provides otherwise. The debtor continues to operate the farm or commercial fishing operation unless the bankruptcy court orders otherwise. And again, back to debtor in possession from Chapter 11, that also applies to Chapter 12. Trying to remember, we do Chapter 11 in the next lectures, so try to remember those similarities and differences there too. The debtor in possession, again, it's a business, so the debtor in possession needs to be able to be fluid in the business and nimble in the business. So the code is designed to allow the debtor in possession to use, sell, or lease property, go get credit if they need it, assume or reject executory contracts and unexpired leases, and obtain continuation of utility services. One of the important differences is this debtor in possession, like Chapter 11, and how adequate protection is provided. So remembering that adequate protection is the concept developed by the Bankruptcy Code that ensures the protection of a creditor's interest in property during a case. Forms of protection that can be provided by a trustee or debtor in possession include replacement liens or cash payments. Sufficient equity in property can also serve as adequate protection. And I guess an example for that, a trucking company must continue to make payments to the bank holding a lien on its trucks and monthly installments on contracts. So that's
That's a really important difference, especially if you think about a business operation. But yet, the creditors continue to be protected, and this protection takes place in the debtor in possession by including replacement liens or cash payments. So, kind of keeping everything the status quo for the best interests of the creditors. Chapter 12 debtor can claim the same exemptions as a Chapter 7 debtor can, and the value of non-exempt property at the time of the filing of the petition is a critical role in the confirmation of the plan, because the value of the non-exempt property relates to the best interests of the creditors test. So on this slide, I decided I'm going to put this in here. Some of these terms keep coming up. Let's look at them more frequently, and that should help everybody remember what they need to remember. But the best interest of the creditors test ensures that each dissenting creditor in a bankruptcy case receives at least as much under the proposed plan as they would in a hypothetical Chapter 7 liquidation. In other words, if the debtor were liquidated, creditors would not be worse off than they would be under the reorganization plan. So then next, the clerk's notice. The clerk must give the debtor, the Chapter 7 trustee, etc. All these folks need to get a notice of the 341 meeting. And Chapter 12 trustee is appointed. After that, notice is after the order for relief. Remember, that's the order for relief. That's the filing of a voluntary. When there's filing of a voluntary petition, there's an order for relief determining that a person or entity is a debtor under the bankruptcy code. In the case of an involuntary petition, the court will enter an actual order for relief if the debtor does not contest the petition or the court finds that the person or entity should be a debtor. So I actually, when I got to this lecture, I just mentioned I wanted to start inserting some common themes that keep coming up. And frankly, the last two, not the one on adverse avoidance, but when I'm running into terms that I want to describe to you, I'm trying to go to the paralegal prep book, the Paralegal's Companion of NALA, and there's a very hefty list of terminology. And my recommendation would be to, I'll secretly tell you, I'm not very fond of the book. I think it's weak, especially if people think that one book is going to take them through this exam. There's more needed. But, so I've used the book to plan this course, but as you motor along in these lectures here, especially in this bankruptcy one, because there's a lot of terminology, I would go to that chart and say, wait, what is that? So if you bought the book for nothing else, that's good. It's a good reason. All right, so the duties of the trustee in a Chapter 12 bankruptcy, like the Chapter 13, and like the 7, they're accountable for all property received, and they perform some of the same duties as does a Chapter 7 trustee. So they look at the proofs of claim at the creditors and see if there's an objection necessary. If they oppose the debtor's discharge, if that's what is in the cards for the debtor. Upon the request of the party in interest, they furnish information to those that request, and making a final report and final accounting is also in the duty. More duties include investigation, operating of the debtor's business, and evaluating the desirability of continuing the business. 11 and 12 have these things in common, that they really are a fiduciary operating a business. And so again, that business lens, it's not, they have a debtor in possession that's operating the business, but the trustee has super mega powers. So indeed, the trustee could literally step in and operate that business. And they are anyway, in an umbrella fashion, walking as a business operator, CEO-ish. The other duties, they need to ensure the debtor makes timely payments defined in the plan, and the trustee has to appear and be heard at any hearing that manages situations on valuation of property subject to a lien, the confirmation of a plan, the modification of the plan after confirmation, and the sale of property of the estate. They have some avoidance powers. Remember, avoidance powers are those powers given to the trustee to recover money that has been improperly transferred, also known as clawback. And they have the same avoidance powers as in other chapters of the Bankruptcy Code. Although the trustee may elect not to exercise the avoidance powers, it doesn't mean that the trustee does not have the power to avoid fraudulent and preferential transfers. Other duties, reviewing the plan. That's the primary roles are right here. Reviewing the plan, advising the bankruptcy court with respect to the plan, and acting as a disbursement agent under the confirmed plan. The meeting of creditors, I think there is a difference. 21, not less than 21, or more than 35. I think the other chapter we looked at last, chapter 13, it was 21, no more than 40. So take a look at that difference. Might be something to just have a bee in your bonnet. Those little quirky little things are the one question that takes you over the top because you knew something quirky. But don't worry about it. Don't sweat it. But if you looking at those little differences, you'll be able to pinpoint those. The U.S. trustee presides at the meeting of creditors. The debtor is examined under oath. Trustee gets assurance that all the debts and assets have been listed in the petition in schedules. Creditors can also question the debtor, and if there's been a plan filed already, there can be questions about the feasibility of it and maybe suggested modifications. All right, so I paused and made that slide a little more valuable by adding the equity security holder definition, someone who owns an equity interest in a company. Remember, we have partnerships and corporations that can be part of can fall into the definition of family farmer or family fisherman. And often partnership and corporations will have some shares of stock or some type of partnership or some type of interest like that. And in the context of bankruptcy law, they hold a financial stake in the debtor's business. But unlike creditors, they're not owed a debt. They're owners. So they can convene meetings. I mean, if you think about, here's another business correlation to make. Imagine a shareholders meeting. Now that we're in bankruptcy, for example, a business is in bankruptcy, well, we're going to have equity security holders meetings. They're shareholder meetings, same thing. So there may be different, I've never worked in this area of the bankruptcy world, but there may be something valuable there to figure out. Anyway. Motions after the order for relief, and again, I remind you folks, we are going to have a whole presentation of 20 or 30 minutes that just covers motions, appeals, and complaints. Most problems are resolved by objecting to the confirmation of the plan, and that's just the truth in any of these situations. They force the debtor to do something. The trustee can force the debtor. Creditors can force the debtor, and since the equity security holders are parties in interest, they can file motions and force the debtor. But going through a confirmation of the plan is where it's like, the debtor's got to cooperate or it may not get approved or confirmed. The debtor has options to convert the case. They can dismiss the case. They can change the venue or ask permission to use cash collateral. They can use avoidance powers. Remember what those are. They can use those powers to avoid a judicial lien, to avoid a non-possessory, non-purchase money security interest. More motions, a party of interest, relief from automatic stay, abstention of the bankruptcy court, dismiss the case, change of venue, disallow claim, convert the case to a 7, relief from co-debtor stay, remember that's for consumer debts only, and for examination of any person, Rule 2004 examination, or for the removal of the debtor as debtor in possession. So they're worried about the integrity of what's going on, so maybe removing the debtor as debtor in possession, put someone else in there. Objecting to the confirmation of the plan, again, that's where some real serious pressure can be put on the debtor. Let's see, almost finished with this. Motions for after the order for relief for the trustee, U.S. trustee. Now that's the super duper higher level. They can move to dismiss the case or again object to the confirmation of the plan, and the Chapter 12 trustee may move to object to the confirmation of the plan. All right, complaints is as opposed to motions. Debtor may file a complaint to collect accounts receivable. So think about this as a business. Again, if they were stuck in some types of bankruptcy like Chapter 7, they would need to either wait the bankruptcy out, possibly, and actually too much can happen to an account receivable in Chapter 7 bankruptcy because it is in fact an asset. In Chapter 12, they're running a business. If I have a shipping business and I've shipped a ton of goods to a client, someone I supply to, and they're not paying me, I need that money for this plan to work. So there's this automatic opportunity that the debtor always has to go into state court and collect the accounts and that sort of thing. To avoid certain transfers. I wanted to give an example I thought of yesterday about avoidance. Years and years ago, my husband and I had a business in Colorado, and we worked for shopping centers. One of them was King Soopers. If you're out there or live around there, you know, out west, you know what I'm talking about. And seems like King Soopers, I don't know, had something to do with either with King Soopers filed bankruptcy or the property management company that was at this King Soopers joint, where, you know, King Soopers store. So imagine a lot of property, and the property managers, they manage it, just like realtors manage rentals. And anyway, we left, we got paid, we left the business, we left town, we went to Wyoming. And then suddenly get this letter in the mail that the bankruptcy court is saying we want your money back. We want what was paid to you by this group. It was either King Soopers or this property management group. We wanted it back. So we literally had to drum up the money. It was about $12,000. So it was just transferred at a time. Payment was made. Bad luck for us. That's all I can say. So anyway, that's to avoid it. So bring the money back. So there's an example of an avoidance opportunity there. Trustee can move to avoid it too. Creditor may want to have the court look to whether or not a debt is dischargeable. So they're still getting paid and getting protected. If it's not discharged, if it's dischargeable, it will be gone. It won't be any money for the creditor. So I don't want that. So that concludes part 1. Sorry it was a little longer than usual, but I guess I'm feeling pretty perky today and getting used to recording mega videos about bankruptcy law, which has actually been a pleasure to be reminded. I worked in bankruptcy for years in Florida, and I actually liked it. I really liked the problem-solving puzzle nature of it, but I've had to bring my brain back. Thank you so much. See you in part 2 of this lecture on Chapter 12. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also, there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.